But one of the things that I have tried to learn through a majority of what I've done on myself is that object, call it the way it is, and make him get a ruling.
Yeah.
The more that you have a ruling, the better odds that you have later on. Now, everybody in the world actually needs to start focusing on declaratory judgments. Declaratory judgments start putting your rights right then and there. The judge will tell you what your rights are. And if they don't tell you what the 14th Amendment is, they don't tell you the codes that they're going after, clearly they're not doing anything.
Right.
They're not going to do anything.
Right.
Finding of facts and conclusions of law, when you're done, ask for it.
Yeah.
Where did you get this? How did you get to it? Granted that the person that's going to be writing it is the person that opposed you.
Right.
But you'll have something in writing when you start appealing for it.
Right. And I think that Robert Garza's talked about this. I think that you have to ask for findings of facts and conclusions of law within a certain time frame, and then ask a second time. Well, I don't know about that. But
yes. So what it is that there's actually a double meaning to this. So whenever you talk to an attorney, what we read is it's right after the judgment is read to you, is that time clock starts. The problem with it is when you go through a case like mine, you're also going through attorney's fees. You're also going through to clean up whether your rights and duties and possession. Then you're going through to enter it all in and your objections to it. So there's 3 more hearings after, and that's a month down the road. You know, it finished in August, and it's December, and I'm just now getting rulings. So if it was in 15 days, he has an opportunity to change all that in that time frame, and it wouldn't match the finding of facts and conclusions of law. Then when you talk to certain other people in the legal profession, it's after the judgment's rendered. You have to ask for it within 20 days. And then after that 20 days, which inevitably is going to happen, you have to remind them. Only then, after that next, I believe they actually get 30 days after the 20. Only then can you actually go after anything else after that. But they get 50 days. Whereas the day that they find out that you're a problem, they can take the kids away.
Yeah.
But yet they don't have to follow any sort of law to have you a recourse or remedy to fight you beyond that.
Yeah.
And it's a hard thing. But I tell anybody that I've talked to that's gone through it is ask for finding of facts and conclusions of law. They may deny it, and if they do, that's fine. But you have something to start with.
Yeah, and I think what you're saying is that make a record. We must create every single thing. Create the record, because if the record is not created, you cannot appeal it.
Nope, you cannot. And that's, you know, and the bad part about this is I had to actually go to my attorney and say, this is my objections. So whenever I got my summary release from them, I typed up my own objections. I told him what I wanted him to say. And then whenever he read it off verbatim for what it was, and he argued a little bit more or didn't argue to this, then I would tell him, hey, this is what you need to say. This is what we failed to do. And it creates an objection. If you didn't object to it, then you can't appeal it. You can't go after it later.
Right.
And who knows this except for the people who's diving into it like we do?
Yeah.
I didn't know this in my divorce.
Yeah.
It took getting to where I'm at now to even worry about or even go research that.
Yeah. With Jeff Younger trial, I was there. And at the end of the trial, there were 2 things that Jeff's attorney asked him. And I'm like, this does not make any sense compared to everything that I've just heard. Okay. It was for one specific reason, to create the record for the appeal.
Okay.
It was just, it was like, where did this come from? And that's when I found out, oh, it's to create the record, because if you don't have it on the record, on the transcript, you can't appeal it.
Right.
But you also mentioned something about objections, and I think that this is one area that that we're very, very weak in. And I saw one of the posts recently, I think it was in the Pro Se Dad group, maybe it was someplace else, about what type of objections to use. Whether it's objections for relevance, objections for facts on evidence, objections for the attorneys testify, whatever it may be.
Right.
But that is something that I believe as well that we need to master. And you know that there are many objections that we can launch, and it's not objection, I don't like what they just said or whatever. This is, you know, it's objections, a legal objection to them, and there are plenty of them, because the attorney, and I've watched it again and again and again with the pro se attorney, they don't know the objections. In fact, there was one case that I was watching, and I was in Sam's Club actually, and I'm watching the stuff going on, and I'm talking to the guy on my phone, but he's not there, right? I'm like, do this.
Yeah,
so then
you gotta play by play here.
I know, but then they went to recess, And I gave him a call and I said, look, objection, he's leading the witness.
Right. Giving the answer in the question.
Yeah. And you know, after there was something else I think too, but after the break and they came back, he used the objection sustained. Shut him down just like that.
Yep.
Because the attorneys are creating a narrative. That's all they're doing is telling a story, and if you do not know the objections, they will take you to the cleaners.
So one of the best cases to actually watch Objections is Johnny Depp.
Mm-hmm.
Go watch that.
Okay.
Camilla does a tremendous job on Objection. If you'll watch, yeah, she's talking here and there, but that microphone is right there in her face, and she's ready. And when they start asking questions, boom, there it is. Camilla Vargas was her name?
Yeah.
Vargas.
I don't know.
She objects on point.
Yeah.
And the problem is that she objects on point. They have to give a rebuttal as to why they can ask it, why they can say it. And if they don't agree, they go to the judge. Majority of her objections are sustained.
Yeah.
Because they're leading. They're trying anything possible.
Yeah.
But, and I'll say this, you have to have a judge. I watched one the other day where a female was pro se. She couldn't find an attorney. She asked for a continuance. The judge said, no, I've already given you time to find an attorney. So she started objecting on her own. And the judge, she was objecting wrong. And the judge would have to work through it. They don't do that for the men. I haven't watched very many that have done that. And when they do it, they already know the objection, but they're waiting on it. And then they rule on it because they know that they couldn't do it, including the opposing counsel.
Yeah.
The opposing counsel even knows that they should have objected. So they'll pause, and then he'll finally catch up, and then the judge will rule on it. But you are exactly right in the fact of, it took me a while to understand what that is, but you have to have a judge that enforces it. The judge in this case, his best response was, move on. Well, that's not a legal term.
That's not a legal term.
I can't appeal that. That's not appealable.
Yeah.
And he didn't like that.
Yeah, you need to rule on the objection.
That's right. And he didn't like it.
Yeah.
And then whenever I had an attorney that was objecting on it, he would rule every time, either whether he, sustained it or overruled.
Yeah.
But he gave a ruling.
Yeah.